Thanks for joining us today, everyone. You probably know who I am. I'm Jonas, events lead, community manager, professionally loud into microphones man for the Limit Break this year. And I mentioned sort of events in there, and well, would you believe it? This is one of our events. This is an event in which we have invited Anna and Rahul from Sheridans to come and basically just tell us how to do IP and contracts and all those lawful things right, how to do it good. I'm sure that was the marketing copy you sent me, guys. Do it good.
Yeah, no, how to do law good.
Do law good.
Yeah.
Don't do law bad, do good.
Don't
please.
do law bad, do law good. Yeah. I think that's it, actually. I think we've covered it.
Exactly. So just if it's helpful, I'm Jonas, pronouns he, him, visual descriptor, someone who wishes he was Moss from the IT crowd. No. Glasses, dark skin, dreadlocks, and today wearing a sort of a vest gilet thing with Limit Break pins on it because I represent the brand. And today we're going to be talking to two wonderful individuals. We've got, well, Anna, do you want to just quickly introduce yourself?
Yeah, sure. Hi everyone, I'm Anna, pronouns she, her. I also have glasses, white skin, curly brown hair, and a fringe that I've had as long as I've had hair. And I am a games lawyer, which basically means I do all of the legal matters that relate to games, focusing particularly on IP, so intellectual property and commercial contracts around that, which is what we're here to talk about today. Rahul, over to you.
So yeah, I'm Rahul. I'm an associate in the video games team at Sheridans as well. Pronouns he, him, and visual descriptor. Brown skin. I've got my hair's basically in a man bun, and I have an impeccable beard, I like to say.
It is impeccable. It's impeccable.
And I'm wearing like this kind of like silky silver shirt thingy. And yeah, I basically do the same as Anna. Work specifically or specialize in IP. And commercial contracts, which we will get into in this presentation. If you know nothing about IP now, hopefully you'll know something about it by the end of this presentation.
Yeah.
Nice. I think on that subject, I'm going to disappear into the ether and just let you two get on with it.
Cool. Sounds good. So just to give you a quick overview of Sheridan, so we are a sort of full service like entertainment and media firm. So all of our departments are things like film and TV, music, sports, interactive, which is the team we're in. You deal with games, fashion, luxury brands, etc. Generally, our games team, we tend to work more on the independent developer side, maybe some like sort of larger developers and small sort of mid-level publishers. Here's a couple of the people we work with. But yeah, I think we've been doing this for a long time. The team's been around for the last like 20, 25 years. So we're quite experienced in working with all you lovely independent developers. And today, so here's a quick roadmap of what we're going to cover. We're just going to give you a sort of brief overview of what intellectual property is and what the different types are, just to help you kind of distinguish between them. The only IP I know is Internet Protocol. Well, that is not going to be covered here.
Yeah, we're not that kind of IP specialist.
So yeah, after we've had a quick tour through the different types, we'll talk to you a little bit about how you as developers or people who work in studios, whether that's on, in your different sort of specialism areas, how you're likely to interact with intellectual property in the development process. And then we'll move on to talk a little bit about key contracts in the games industry, how, either if you're working in a studio as a contractor, doing some work for hire stuff, or whether you join a studio as an employee, or whether you're running your own, you're working in your own indie studio and you're actually looking at the publishing deal for your game. We'll run through some of those contracts and some of the key things to look out for in those.
And also I'm going to jump in here and be the bad guy. Sadly, none of this is legal advice. But for something to put in, then come speak to us after class. But yeah, as you
exactly. Good point. Always got to put the disclaimer in.
Yeah.
So yeah, we'll start off by what is intellectual property. It sounds quite mystical. And effectively, the best way to define it is sort of, we call that creations of the mind, inventions, or sort of intangible property. So when you think about physical property, for example, a car, if you purchase a car, you have physical ownership of it. But obviously, if you write a song and you've got the song itself, it's not a physical object. And so a song, for example, would be a type of intellectual property. The key types of intellectual property we're going to talk about today: copyright, trademarks, design rights, and patents. And yeah, we will go through them one by one, and there will be some interactive elements to it as well. So hopefully you won't just be bored of us talking about this for the next 45 minutes or so.
Yeah, and I think good one to start with is copyright, arguably one of the most important IP right for games, because this is, firstly, it's an automatic right. Certainly in the UK, it just arises as soon as the work is created, and this covers a wide range of original creative works: so literary works, text, dialogue, art, music, software, and it applies once this work is fixed in a tangible medium, once it is expressed. So it does not extend to ideas. A creation has to have been written, drawn, recorded, so expressed in some physical, tangible way to be protected. And it also won't protect anything generic. So an interesting point around this, as some of you may know, game mechanics generally aren't protectable, but I don't know, if you're looking at the specific written rules for a game, then they might be, if they're written in a particularly creative way. So it's the code that makes up a game that then results in game mechanics, that might be protected because it's specifically written and expressed. And a helpful way sometimes I find to think about this is an example I sometimes use is just a super basic example: card game Snap. So the idea of matching cards and first shouting Snap, no, that's too kind of just generic and general. But if we're talking about quite specific and creative wording that sets out the rules for this game, and then when you match cards, everyone shouts Fimble Slam, then yes. And Fimble Slam's my copyright now, so
we will get to the patent stuff, don't you worry.
Yeah, so this is copyright, which is distinct from patents. To give, so just to kind of, and this, for this next bit, it would be great for people to just jump in and see what they think. We're going to set out a number of examples of things, works, and we want you to tell us which you think would be protectable by copyright and which wouldn't.
So here we go. Let's start in the top left. So we showed the example of sort of Lara Croft and sort of Tomb Raider and Uncharted. That's a good example of games. There are certain things that can be protected by copyright and certain things that can't. And so we will start from the top left. Do we think the character of Lara Croft can be protected by copyright? Feel free to just shout out, unmute.
Yes. Lots of yeps.
Lots of yeps. Yep, spawn. That is correct. Yeah. It is an original character. Obviously, it's on the screen, so it's expressed in a way it's original. So yes, the character of Lara Croft can be protected. Let's move to top right. The genre of a third-person action platformer game.
Getting some nays.
We get some nays, and that is spot on. That cannot be protected, because if it was, I think the first game to ever do that would be the only game that exists in that genre.
Yeah.
There would be no, Uncharted would not be able to exist, because it is both, both Tomb Raider and Uncharted are third-person action platformer games. The song Nate's Theme from the Uncharted OST, what do we think? Yays. Yep, exactly.
Yays. Thumbs up, some yays. Yep.
I think you guys are nailing it. You guys are all over this copyright stuff. This one is for the OGs who would have played this game. The gameplay mechanic of being able to lock a butler in the freezer. No, they should be. Lol, no, that is correct. That you cannot, as Anna sort of alluded to in the previous slide, mechanics specifically they're too generic. You can't protect them. You can't stop any other company from having a game mechanic where you can lock someone in a freezer. You'd not be making a whole game around mechanic. Excellent. Okay, I think these are going to be too easy for you guys, but we'll go through them. The game title, Shadow of the Tomb Raider, can that be protected?
But the 3 PM.
Yes. You've all got it. The narrative or storyline for a game of a globe-trotting explorer on the hunt for hidden treasure, can that be protected? Nope.
We've got some no's and yeses. So this is no. This is too general of a concept.
Yes, exactly. That is correct. And then, but to make it more specific, the script and sort of dialogue in Uncharted 2 Amongst Thieves. Yes, exactly. That is a much more specific, original way of sort of recording a literary work, and so it would be protected. We don't go into in this presentation we don't really talk about IP infringement.
That could be a whole session.
That's a whole other. That's a whole other thing.
You don't have to answer them on Derailer. No, Derailers are good. It's fine. We want people to throw in ideas.
But yeah, spot on. You guys pretty much got the picture. You've got all of them right. So good job.
Nice. Should we chat about trademarks? Yeah, trademarks.
Oh yeah, so moving on to trademarks. These are it's a way to identify where goods or services have come from. So it is a mark. It can be a word, it can be an image, it could be a combination of the two. And this is something that you have to register. So I get, just to confirm, with copyright, it exists automatically as soon as you create a work that is eligible to be protected by it. So as soon as you write the composition for a song and you've got, the sheet music, that is automatically protected from the moment that you wrote it. Or as soon as you write the script or you've written the code for your game, that's automatically protected. Trademarks different, they have to be registered. It does cost money to register them, and it has to be done on a country by country or territory by territory basis. I think that the big sort of benefit of having a trademark is that it prevents you with the tools to prevent other people from using similar marks. So as we said, trademarks are a way to identify like where a good or service has come from. So we have example of the Nintendo seal of quality. So whenever you pick up a Nintendo game, I think to this day they still have that on like physical boxes. You would see that and be like, oh, this is a Nintendo game. And generally speaking, they have a good reputation, known to be like high quality games. So what if another company who made video games just slapped the Nintendo seal of quality sticker on the back, or they put that label on their physical box, a consumer might look at it and be like, oh, this is a Nintendo game, this is going to be good. It might be an absolutely terrible game, and they've just taken that label to kind of give themselves some sort of authenticity or something, and they're effectively like riding off the reputation that Nintendo's built for making good quality games. So trademark will help you stop that from happening. So a trademark is infringed if someone uses the same or very similar mark in a commercial or business sense, and that use misleads or confuses the public. Ripping that label off all my creations. Good, Jonas, do that. And yeah, just another quick one. A way that you can recognize a trademark is usually you'll see a little TM in the corner of the mark somewhere, so you can see it just sort of in the bottom right corner. Or
it'll be like a little R in a circle, which means registered trademark.
Yeah. What about parody seals? Well, for parody.
Again, we'll have to cover that in our infringement talk, I reckon.
Yeah, I think we're going to have to do an infringement talk, because that's like a whole different element.
Yeah, parody relates more to, it's a defense for copyright infringement, but it doesn't cover trademark infringement, which is a very useful distinction to know.
Right, I think we're going to have to do a part 2.
Yeah, I think we'll do a part 2, which is a fun one. Infringement is fun, not the activity. That's Don't go and infringe. Should we chat a bit about design rights as well.
Yes.
Which, so this is interesting. So this is, as it says here, it's a slightly more niche type of IP right, and it's, you know, it's generally used for, as it says there, things with a specific pattern or strange, you know, shape, layout, symbol, the sort of almost more of a, like a kind of technical design. So an example might be buildings or maps. So if you're using in your game, for example, a specific map from a real building or a real place, then you might want to check for design rights. We've got a picture of the Empire State Building, for example. I want to just, you know, have a look at this. An example, a good example. This is, for example, the Spider-Man game. There are you know, quite a few real New York City landmarks in that, but it is missing, or there are certain key ones that have been adjusted in certain ways. If you know, take a look at their version of the Chrysler Building, you'll notice that it's not the Chrysler Building as a protected design under US laws. And the same copy applies to any copies of real cars or weapons. So we've got a couple of pictures there. For those who you recognize, one on the left is from GTA 5, and one on the right is the Lamborghini. I can't remember the full title of it. Rahul, perhaps you remember.
It's like a Lamborghini Huracan or something like that.
There we go. Yeah. And so to get around the design rights in the real Lamborghini, Rockstar altered the design in a few places, and you can see, you know, for example, the front bumper. It's a bit different. It's got a slightly, you know, lifted roof, the window shape, the wheel shape. All of this to get away from the actual design rights that they would have had in the car. In some cases, there can be overlap in this with trademarks and even copyright. So if a car manufacturer is getting annoyed, they might try and throw out design rights, trademark rights if they've got a 3D mark, copyright. But design rights they're the ones where it gets really specific. You'll also notice that in the game they don't refer to this car as a Lamborghini for various obvious reasons, as we now know, most likely trademarked.
Exactly. And yeah, so the last one we just want to run through are patents. So obviously someone asked a question about it already. Patents protect new inventions, but it's not sort of new inventions in the way you might think. So even if you invent a new game mechanic, that in itself cannot be protected by a patent. But what can be is the technical process behind how you made that new mechanic or your method of achieving it. So if if we take the Nemesis system, someone raised a question about it. You can't protect the idea of having enemies remember your actions throughout the game and interact with you differently based on their memory of your actions. Like that can't be protected. But whatever code was written by, who would it have been? Was it like the Warner Brothers, Rocksteady? No, not Rocksteady. Who developed the game again? I can't remember. But whatever code they wrote to achieve that result, their method of doing that was unique, and it was a technical process, and they invented that technique, and it's that is protected by a patent. Now, obviously, if another company develops a different way to achieve that same result, then the patent is not, they're not breaching the patent, but generally the patent is still helpful because it stops other people from being able to reverse engineer your code and figure out how you did it. So you may have put 5 years of development work into writing this incredible code that achieves this really cool gameplay mechanic, and then another company can go and basically just reverse engineer it, and within a couple months they've achieved the same result. So that's what the patent will stop them from doing. Obviously, if they invent their own way of doing something which achieves the same thing, then the patent doesn't really help. But the cool thing, oh, go ahead.
No, carry on. Sorry.
No, but the cool thing about if you do get a patent successfully, it gives you a monopoly right over it. It basically means you can prevent other people from using your method. You see it a lot in like other industries like pharmaceuticals. If they develop a new drug, they patent it, then the method of developing that drug other people can't use. But the actual patents themselves have to be extremely like specific And because we're talking about a very technical type of protection, you really have to explain what it is about your invention which is unique, and you have to be very articulate and specific in what that sort of invention is, because what they're not trying to do with patents is block innovation in an industry. Because if you could protect a game mechanic just in itself, then the Nemesis system's in one game and no one can iterate or build upon it, or the games industry is a very iterative industry. Everyone builds upon what's come before, and we don't want to block that from happening with patents. But it is, if you have put the work in and invented something new, you should be able to have a benefit from it.
And it's like very technically new. And one thing also just to flag with patents is that it takes a very long time to get them. Sorry, I don't know if you heard that, someone being loud at my door. But it takes a long time to get them, and they're also very expensive. They can be quite expensive to get. So chances are by the time the patent's actually been fully granted, the game would have been out for quite a long time, as was the case with the Nemesis system. So it's rare, particularly in the UK and EU. Sometimes you get it in the US, but it's an interesting one, if not necessarily the most useful for all developers.
But we want to make this interactive, so we want to give you an example of what patents will look like. So what we've done is we've taken 2 extracts from 2 different video games patents, and you have to guess what they are trying to protect, like what element of a game is it protecting. So here we go. Here's the first one. I won't read it out loud because it's very technical. But have a read of that, and then feel free to either unmute yourselves and just shout out what you think it is, or you can type in chat. We'll give you a couple of seconds to have a read. Stunned silence.
I'm going to go out on a limb and say a yes for this one, because it sounds like a specific device, like racing car models that I've seen, like you say, in the arcade, that seem to be individual.
Oh, I mean, so this is an actual patent that was granted. Both of the extracts are actual patents that were granted. I guess we're trying to get you to guess
some sort of racing. I think you're getting
we're trying to kind of
a
ghost car from Andrew Frey.
Do
you have any other guesses?
Can I have your permission to actually read out the text really quickly?
Of course, please feel free.
Just for accessibility reasons, the font is actually an issue. So, sorry everyone, but I'm going to cut in. I'm going to read out the whole thing. So this is Extract 1. A training system for a user of a simulated vehicle. The system includes input devices for controlling the simulated vehicle, a video display having 3-dimensional graphics modeling software for determining position information based on the input devices, and recursive training software to display a previous route through an environment simultaneously with a present route through the environment. I realize that's really hard to hold in your head, but I hope that helps a little bit if you weren't able to read that.
But thank you for that. That was beautifully read, Jonas. And just in the interest of time, because we did have the correct answer previously. Shout out to Andrew Frey. You are correct. It is the ghost car. So that was the method of achieving a system of basically having a previous route through a environment being like overlaid simultaneously with the present route, i.e. your current like gameplay. That was patented by, I think it was a company called Midway, and it was an arcade game. It was like an old school arcade cabinet, and whoever had the top score, like the fastest time on a track on the machine, they had an option where you could have their ghost time, and then when you put your money in, you have your go of playing, you can see what the best time was on the track. And as soon as the patent ran out, pretty much every racing game we know has that mechanic. This is a clip, this screenshot from Gran Turismo, but Mario Kart, all the greats have have ghost car mechanics. So here's the next one. I will read this one out, unless Jonas wants to jump back in and read it, because you did it so beautifully the first time.
No, it's your event, you go for it. I just thought I'd really put a note there that someone would benefit.
Cool. So Extract 2, so this is another patent that does exist. I I don't know. We've done this presentation. We've done this before. Some people have said this was easier than the first one. Some people said it's harder. So a game system comprising a data processing system configured to execute program instructions, allowing a user to engage in digital gameplay, a physical toy, and a detection device configured to detect the presence of the physical toy within a detection area of the detection device, wherein the data processing system is configured to control said digital gameplay responsive to the detected subset of identification elements. So very, very technical, a bunch of words. But yeah, we're already getting some answers coming into chat, and you guys are spot on. So yes, it's effectively the mechanic of toys to life. So the interesting thing about this, the reason I want to bring this one up is, as I said earlier, patents are monopoly rights. So if you're the first person to come up with a system of doing something, or like an inventive process, you are the only people who get to do it. Now, I can't actually remember which one came first, if it was Skylanders or whether it was Disney Infinity. But whichever one it was, they effectively, I think it is Skylanders, but I'm not 100% sure. But what they decided to do, instead of keep the monopoly right to themselves, they said, well, how about we just sell we basically let other people use it if they pay us. So they turned their monopoly patent into a commercial revenue stream, where they effectively said, okay, like, yeah, we could be the only ones who are allowed to do toys to life, which, you know, it might take off and be the next big thing, or we can let other companies do it and, you know, get some money for ourselves. And so that's why in a very quick succession you saw Skylanders, Disney Infinity, Lego Dimensions, and I don't know exactly if I think Amiibos might be separate to all of that, because they had a different technical process for achieving the result that they did. So I don't think Amiibos were in the same thing, but yeah, it's along the same vein. But yeah, as you can see, patents, extremely technical, very, very specific, can be very confusing. But hopefully that's helped sort of demystify it a little bit.
So basically what we've run through so far are the kind of the 4 core IP rights to be aware of. And so now that you have an understanding of these key rights, the next step, and the final step when you're doing any kind of work creating a game, would be to clear it before it's shared with the public. And this is a crucial step. And it's, as it says on the slide, it's something that developers or publishers will do this with the help of lawyers to basically look at what risks there are of potential IP infringement. So I think to bear in mind when talking about clearance is that there are effectively only 3 ways that you can use intellectual property. It's either owned, it's licensed, or it's infringed. So if it's a specific IP, it's not, you know, just generic ideas. You want it to fall into the first 2. You don't want to be in that last one. And we'll look later in this presentation at the difference between ownership and licensing. But clearance will come into play with this as well. So if you're using licensed IP, for example, you need to make sure that the works you've incorporated into your game are in compliance with the original license. And that if there's any IP that isn't yours, that you're not inadvertently infringing someone else's work. So it's easier with this to give an example of what we mean, of how you might go about a clearance exercise. So again, we want you to, okay, so here's an image. And we basically want you to just shout out, you know, you can come off mute or jump into the, you know, drop in the chat what you think are the potential areas of risk here. What are the key things that we'd be looking at as lawyers? Yeah, Vicky, you've got your hand up.
Yeah, just all of the logos, really.
Logos, yeah,
100%.
Very much.
Always, yeah, they're always, and there's quite a few. You've got the ones on the to the left there, and then also a few on sort of on the right. So that's always a big one. any other suggestions? Any other thoughts of what could be a risk here? Again.
The police design vehicle, like how do you portray the police in this city?
Police is a very interesting one, yes, and we're going to chat about police and things like FBI specifically in a bit, because there are some considerations around that, around how they are portrayed, and if you're using, for example, some police, specific, there might be specific registered trademarks in the logos and seals that they have. So yes, that's out.
I saw logo on cap and weapon. Both of those are correct. I remember specifically I had to do I was helping a company with a clearance exercise, and we were working, there's a few of us in the team, and one of us was given clothes, one of us was given something else. I was given firearms, so I had to do a very long and in-depth amount of Googling and researching like design right registers for firearms and different guns. So my IT team was not particularly happy with me because they saw my Google search history and it's just like, why are you looking up design rights for firearms all day? So that was fun.
Yeah. Was it font use and top right? Yeah, fonts is a very good shout. There can be quite specific own proprietary fonts. So yeah, good call there.
I think we've got the main ones. Yeah.
There's one more that I want to just see if anyone. It's basically in the. I don't know if anyone can see in the bottom left. There is a little map, a bird's eye view of map. And there again, you might have design rights, for example, particularly with race tracks. There might be some quite famous race tracks, or if you've got that, then map in the in the corner that might be protected.
Nice. And we do have another image just to give you sort of another set of examples. So this is from Watch Dogs 3, I believe it is. So yeah, feel free to just shout out or throw in chat any suggestions of what we'd be looking at for here. There's a couple interesting ones. The red icon in the bottom right.
Interesting.
Ooh. Was that on the previous image or was that on this one? Bottom right.
Mm-hmm.
Oh,
in the last slide, yeah. Yeah.
Yeah, I guess so. Yeah, that's like just the YouTube icon, I think. But yeah.
But yeah, so yeah, clothes. Clothes is a good one. There will be all sorts of rights in certain specific, particularly quite unique designs. And again, always checking for any logos or anything that might be on that.
Nice. I think the two
street art,
sort of,
yeah, street art and the flag.
And the flag's an interesting one as well. But yeah, the street art, 100%. It could be a copyright work by a famous artist, so you have to be careful that you're not just ripping off someone's art and just putting it into the game. We've got the clothes, again, the firearm, the flags are an interesting one because sometimes the flags themselves are registered. And then sometimes, I think someone alluded to it as well about your portrayal of certain countries in games, and it sort of strays a little bit away from sort of the hard IP rights that we've talked about. But for example, in certain games, like particularly like Call of Duty, you will probably notice that none of the countries that they mention in the campaign are real countries, and they never show any real countries' flags. This is Watch Dogs Legion. Yeah.
And with on the flags point as well, I'm sure some of you might be aware that there's an increasing amount of regulation at the moment that's just been coming into force, and like this year, like quite now, and like last year, quite recent. That's all to do with moderating content, online games, and anything that could be deemed some kind of platform, which could include any kind of like COD or something where it's got an online sort of in-game chat feature or something. That basically relates to how people interrelate with each other, and if there's anything that might start straying into slightly dangerous territory or just negative connotations towards any certain countries, like developers, publishers are under more and more stringent obligations now to sort of be careful with the content that people are sharing and talking about in their game. So it's an interesting one.
And yeah, just to see the comment from Danny about the NHS being mentioned. Yeah, I think it being mentioned, and I think we're going to come on to it a bit when Anna talks more about like sort of police and things like that. But generally speaking, like if they were using the NHS logo and sort of these like protected works, they may have had to that's exactly what they would have had to do a clearance exercise on. Of is this registered? Do we need to get permission to put this in the game? They'd have to go down like they'd have to sort of speak with lawyers or do some sort of risk assessment as like internally as to whether they can include it in the game or how they include it in the game. Like one interesting thing specifically about Watch Dogs Legions is apparently like post boxes in Britain. The red sort of columns that you see on the street. Those are registered like trademark. They're registered designs. So if you wanted to put like those exact post boxes in your game, you technically would have to go through a clearance exercise and get permission.
Yeah. And there's also, I see some questions here around actual people in the games as well. I mean, there's a whole sort of spectrum of things to look at when it comes to that. Rahul does particularly quite a lot of work with around sort of influencer contracts and things like that, and that touches on this as well when you're talking about, particularly a famous person and then how their image is used and how they're kind of, there'll be all sorts of their agents will come down like a ton of brick. But
I feel like we've got like 2-3 other presentations we could do.
Yeah, we need to do a whole separate one on that. So I'm not even going to open that kind of ones, but it's a very good, interesting point. But yeah, basically an overarching thing with this is you kind of have to take a bit of a risk-based approach, and what we will often do is help do a kind of a traffic-like system of green, amber, red. Green being like, yes, it's very fine. Amber, look, there's going to be some risks. Here are the risks, but you can tweak some things to make it work. And red being like, just don't go near it. Please don't put that in. You're probably going to get sued if you do. And the reason that we've got a couple of clippings from to do with the Tolkien estate here, you don't need to read it. It's just for as an example of basically a brand owner. There are various brand owners that are known for being particularly protective of their IP. Tolkien estate famously, protective of Lord of the Rings IP, tried to shut down the Hobbit pub, came down hard on Warner Brothers for use of Lord of the Rings IP that they felt damaged Tolkien's legacy. So as soon as you see, for example, anything Lord of the Rings related, you know that it's going to be slightly higher risk. Nintendo, I think I saw someone, was it Jonas, I'm not sure, in the chat mentioning about Nintendo's lawyers and their
very
infamous stance. They're very often the sort of the more outwardly kind of cheerful and friendly the brand, the more ferocious their lawyers are in the background, to really protect that image of their brand. Disney is the same, Lego. So there are certain sort of owners and types of IP that it's just going to ratchet up the risk slightly. And then, we've had a fair bit of discussion around, a few people mentioned things like police, and they mentioned FBI earlier, and things like NHS. It's an interesting one because I'm sure you've all seen, this is an example. So we've got here, the FBI logo in the middle, but as we know, it's quite common in popular media to see, you have FBI agents in games. We've got CS:GO, COD, Hitman, GTA, Saints Row. Even though FBI and Federal Bureau of Investigation are actually registered trademarks, together with the logo and the emblem, they're actually protected under US federal law, which should prohibit use of them in any manner that could convey the impression that the FBI has in any way approved or endorsed or authorized use of their name and logo. But actually, the risk, is often not necessarily that high to use FBA, provided you're not, provided you're using it in just a general descriptive sense. So you're not trying to make it seem like it's some badge of origin to say, yes, this is an FBI product. And, use in games, it's not generally going to imply that the FBI has endorsed it or in some way associated with the game. And if it's there to kind of just enhance the realism of the game, and this would have, there was a case with Activision a while back around the use of the Humvee in Call of Duty, and the courts found that they could use Humvee because it didn't constitute trademark infringement because it was just enhancing the realism of the game. And when you're thinking about things like, the same would apply for FBI, for the police. If you're not referring to them in an offensive or derogatory way, there's unlikely to be any issue from like a defamation perspective. So there are ways of, even if it's a sort of registered trademark, there are still potentially ways of using them in safe safe ways if you're being careful. And as we say, it's quite prevalent in popular media, so in certain cases the risk isn't actually that high. I'm just checking the chat here, but yeah, so that's basically a bit of a whistle-stop tour through it, giving you an introduction to IP and how to handle it in games. I think we'll shift slightly now and just look at also how you deal with it in your business relationships and day-to-day, contracts and things that you're going to want to be aware of as you go forward.
Yeah, I think we just wanted to kind of use this to demonstrate to you, like, this is the kind of discussion that would go on in a studio. If you're designing art assets, or you're designing an environment, or you're a character designer, or you're writing the dialogue, you will be thinking about clearance and what's the origin of this? Have we copied it from somewhere? What's our inspiration for this? Have we changed it enough? So yeah, that's kind of how you might be interacting with IP if you worked in a studio, or on the sort of throughout the development process. But now we move on to contracts. Yay! Everyone loves contracts. Woo! So we're gonna kind of talk through 3 of the sort of most common contracts you'll come across most likely in your careers working in games. So we've got IP licenses and IP assignments. You've got contractor agreements, and then your big old development and publishing contract. So we'll take you through a quick tour through these over the next 10 minutes or so, and then hopefully we'll still have a bit of time for questions at the end. So what is an IP assignment? What is an IP license? This is a key difference to sort of get to grips with. If you assign your IP to someone, you're transferring the ownership of it. If you are licensing your IP to someone, you are granting them permission to use it in a specific way based on whatever's written in the license. So, if I've come up with a character, like, Lara Croft, for example, if I transfer ownership of it, it means I no longer own any of the intellectual property relating to that character. It now belongs to the next person. If I license it to them, I still own it, but I'm giving someone permission to use it in whatever context of whatever the context of our agreement is. So again, just kind of be aware of that. It's super common in the games industry, and some of the most beloved games of all time only exist because of very complicated licensing agreements. And I'm sure many of you will recognize this. Super Smash Bros. Probably one of those classic, like, everyone is here moments. So obviously Nintendo own Super Smash Brothers. They own all the IP behind sort of the branding of the name Super Smash Brothers. But obviously Nintendo do not own all of the characters. So we have some examples here. Just in the interest of time, I won't get you guys to shout them all out, but feel free to do it in chat as I'm talking through them. We've got Sonic, we've got Snake, Ryu, Cloud, and Pac-Man Circle. So obviously these have come about from licensing agreements for all of them. So obviously for Sonic, we have Sega. For Snake, we have Konami. For Ryu, we have Capcom. For Cloud, we have Square Enix, and Pac-Man, of course, Bandai Namco. So yeah, one of the probably best examples in the games industry of very complicated licensing agreements, because these are just a handful of characters, but there's obviously so many more. But yeah, so this kind of gives you an idea.
Yeah, also I'm sort of taking notes of the questions and comments in the chat, so we'll see how many we can get into at the end with the Q&A, and also we're super happy to chat with people after this. You can drop us an email, so you have been heard, don't worry. But yeah, looking at employment and contractor agreements, if you are engaged on a project, it's a key way of thinking about what happens to your IP. So if you're an employee, the general position at law is that anything you create automatically belongs to the company that you are employed by. If you're a contractor, the position is that it automatically vests in you, the contractor. So from both sides, as the employer or the person the hiring company and also as the person being hired, you want to think about particularly what happens to those works. And it is for this reason standard to have in an agreement, and as we say here, please make sure it's in writing. Really, it helps. It just clarifies everything for everyone. So you will usually have an assignment of IP. Even if it's an employment agreement, it's automatic. You'd still have an assignment. Particularly for contractual agreements, it is standard practice to have an assignment to the company that's hiring you. That's often referred to as a work for hire agreement in contract agreements, and that's usual. That's to be expected. But there are still some things to think about, particularly as a contractor, when you're going into one of these agreements. One thing you want to think about is do you need to carve out any of your own personal work or any kind of pre-existing work to prevent that being signed over to the employer, so that the employer doesn't own something that is actually your own creation that was separate to that project. So you might in some cases need to think about a split between an assignment of the core stuff that you're making for the party that's hiring you, and then a license of your own pre-existing stuff. You want to think about as well things around just generally the approvals process for the work that you create. So can the hiring party just unreasonably withhold consent? Like, what are the parameters for their approval of what you're creating, particularly if payment might be contingent on their approval? And we could, again, this could be an entire presentation in itself. This is just to sort of so that when you're going through, to think, this is something that's important, I should pay attention to. Termination as well is always a key thing to look at. So can the hiring party just terminate for any reason, or for no reason at all? So for convenience, would that leave you in the lurch if they do? So do you get some kind of kill fee? So some kind of payment if they're just terminating because they want to, or can they just quite easily terminate for any minor breach? And if it is for any breach, check what your obligations as licensee, as the contractor are. Like, there could be some minor obligation around how you deliver the works that you hadn't fully absorbed, or some an element of a morality clause or something about crediting the company properly. I don't know whatever it is, but a small breach of that could mean that the agreement could be terminated. So it's just something to sort of look closely at, how they can actually terminate, what happens to the works that you've licensed some work to them, what happens to that on termination. And this is a sort of thing that will actually apply across the board in a lot of different contracts. So publishing and development agreements that Rahul's going to talk about, you'd want to be thinking about the same sort of thing. Yeah. But yeah, I mean, Rahul, do you want to take it? There are some differences.
I think one other thing, just to kind of demonstrate, because I think one thing we always get a bit of concern about from developers when you talk about assignment and licensing of IP is, when you work as a contractor for a company, you may be asked, the contract might say, everything that you create for us during your employment will be owned by the company. And while that does feel like, I'm assigning all my IP away, I think practically it kind of makes sense when you're working on a game, because what you don't want is a situation where, let's say you're an environment artist and your job is creating certain levels or certain like visual assets in the environment, trees, clouds, houses, whatever. If you as an individual owned those assets and for some reason you decided not to give them permission to use them when the game comes out, or you leave your job, it just becomes difficult for them to exploit the game and sort of finish the game if like hundreds of contractors all individually own the bits they create. So it's not necessarily like a scary thing to assign your IP to someone else, but it's just, you should be conscious and aware of which one is happening. Like, are you licensing something or is it being assigned? Just want to flag that. So yeah, we'll quickly run through development publishing agreements. Again, this is probably more relevant if you are sort of running a studio or you're in sort of the business or legal team of a studio. If you are more on the actual creative development side, you're probably not going to be dealing with these too much. But we thought, just in case, there's a range of people in this call, so maybe you might be sort of having to deal with these types of agreements. Usually the big thing about them is they're structured in a format that we refer to as sort of milestones and deliverables. So if you are a studio going to a publisher, there's a couple of reasons why you would do that. A big one is funding. Obviously, developing games is expensive. A lot of studios, you don't generate any money until the game is done. So, but you obviously need money to be able to like survive for the 3 to 5 year process, on average that it takes to make most games these days. So a publisher will usually provide funding for that period of time, but it's very unlikely that they're going to give you it all in a massive lump sum up front. So normally contracts are split into milestones and deliverables. So they'll say, right, you think it's going to take you 3 years to make this game. Every 6 months, you need to deliver to us a build of the game that includes all of these features. And if we're happy with it, we'll give you a chunk of money and you can keep making the rest of the game. And you keep going through that process until the game's done, or if it all falls apart halfway through, you might decide to end the project or whatever. But again, it's very unlikely you're going to get like $1 million upfront from a publisher. So they usually are split into this kind of structure. Again, as I said, revenue share, that's an important thing to look out for in your contracts, just because, again, you're not generating any money until the game comes out, but obviously a publisher has given you money up front. So what will usually happen is once the game does come out and starts generating some revenue, the publisher or whoever funded the game will sort of recoup their money first, and then you will split whatever comes after that in a certain percentage. So again, that's a very important provision to look out for, and make sure you understand how that revenue share works, at what point, like how much they recoup, at what point it changes from a certain percentage to something else, or just make sure you understand that. Creative control is a big one, because you probably want to, as a developer, or most of you probably on the development side, even if you get into a publishing agreement, you want creative control of your game and the content inside of it. There's been examples in the past where not even that long ago, where publishers have said, oh, we want you to make the game multiplayer because games as a service, that's where the money's at, or we want you to incorporate NFTs into our game or into the game because Web3, that's where it's at. So again, be careful about what your publishing contracts say about who has the final say about the style of the game, the content of the game, even the genre of the game. And then the last thing, just to draw attention to, something just I've bundled together as ancillary rights. You have to be really careful when you're looking at your publishing agreements, because obviously in our heads, we're thinking about, oh, this is the publishing agreement for our game, like just the current game we're working on. But if you're a publisher, especially if you're funding the game, you might you're taking a bit of a risk on it. You don't know if it's going to be successful, but if it is successful, because you funded it, you might want certain rights. For example, if the game's only coming out on PC, we want the right to be the publisher if it comes out on console, or if you're making ports, or if this game comes out and becomes a really successful franchise and it turns into a TV show, well, we want to get a percentage of the money from that. Or if you start making merchandise based on this game, we as the publisher want some of the money from that as well. And again, nothing wrong with that. You see that in a lot of contracts, but it's just making sure that you're aware of that. And yeah, so here are some examples of that. So Vampire Survivors originally released on PC, but then it was ported to consoles. We've got the Fallout TV show, obviously based on the hit video game franchise. And a very topical one now, obviously, we've got the Horizon Lego set. So this is a physical Lego set, but they obviously just announced the Horizon Lego video game at Summer Games Fest. Very exciting. So yeah, these are some examples of the things that may also be covered in development and publishing contracts, even though you might off the bat think it's just about the current game.
And Lena, to your question there on the Fallout show, I mean, that I didn't work on it personally, but we would have been looking at a license for that, but it would have originally spun, as an example, if you were licensing your IP for a publishing agreement, and then there were ancillary rights. Those ancillary rights would be, as Rahul was saying, it would cover things like spin-off media. Sometimes what you do see as well is a right of first refusal. So if one party is interested in doing something wonderful with the IP, then they'd come to the other party first and give them a chance to talk about it before they go to anyone else.
But yeah, that was our quick whistle-stop tour through some legal contracts in the games industry and IP in general. We have basically run out of time.
we have 1 minute, and I know there's quite a few questions as well that I've been trying to take note of. So I know Vicky, you asked ages ago about the difference between the TM and the R. But just quickly, the R means it's a registered trademark. TM means, this is English, in England, TM means that it's not a registered trademark, but it's being used in a trademark sense. So that's what that is. We also, we had some questions around, actual faces, faces of historical figures. Your question around what happens if it's an actual person. Rahul, I know you need to jump off at hard stop at 2,
Yes.
so if you need to jump off, then fine, I can.
I was just going to say, do you want me to jump in? I'll jump in really quickly. So
No,
firstly,
I will love you and leave you, but thank you very much for having us. I hope you found it interesting. And Anna, if you want to put our
I'll put our
email addresses in the chat. If we can't get to answering your questions here, feel free to drop us a line, and then we'll try and get back to you as soon as we can.
Yeah, absolutely.
Yes, thank you so much, everyone, and take care. Have a good weekend.
Yeah, see you, Rahul. Thank you so much.
All right, bye.
Cool. Yes. No, very aware of the time, so wanted to make sure that Rahul got the chance to cut in and get out while he can. And then what I want to do is, before we jump into these questions, Anna, I'm going to sort of give you a multiple sort of choice narrative tree now, go left, go right.
Okay.
This is the video game we're playing all along. We can sit and answer the questions in chat here, but also I was wondering, is it maybe worth if we get these questions up in the Limit Break Slack, which I assume you're in the Limit Break Slack, actually. It's a good point.
If I'm not, then I can be. I should be. I want to be.
Exactly.
I'll FOMO that I'm not.
Because I was also just thinking we could take it to text, so that way you can type out some comprehensive answers, and potentially like Rahul can come back in and answer some questions later in our Slack channel. And
also if anyone has questions, because some of them I think there can be quite a few elements to think about. So I'm happy to chat. Just you can drop us an email if you want to just expand on that, and just have a chat. We're not going to charge just for a chat, obviously. But especially if there's some like confidential stuff that you want to talk about that you'd rather not share publicly, then that's also fine. Why don't we do that? Because people may have other things they want to jump to, and don't want to keep people. So we can do this on Slack, do this just by email, however everyone wants to do it. But
let's what I'll do is just to respect everyone's time, because again, I really do want to make sure that these events, like, they end when we say they're going to end, just to respect like your time as the professional coming in to speak, but just also to respect that some of our viewers might not be able to stay for like an extended period of time. This might be your lunch break, you might be kind of sneaking off to be part of this event. Just to manage our time better. So first off, in chat, Anna, you have put your email address and you have put Rahul's email address. Thank you so much for doing that.
There is also a Limit Break email, which will take you to me and Rahul, and also our colleague Antonia, who is worked with Limit Break for actually also she's super hot on data related questions as well. I will look up that email, but I think it might just be Sheridans at Limit Break or something.
Nice.
But I'll find out and try and drop that in the chat if I can.
What I'll do for everyone is, if you register to the Luma page for this event, which I think you must have to get the link, then I will send you all a follow-up email. I'll make sure that these email addresses are included. I'll make sure that the generic email address that we give out to everyone in Limit Break is included. And I will start a little thread in our help events chat in the Slack, and that thread can just be used as a little like, hey, I had questions for Sheridans that didn't get answered in the event, and then Anna and Rahul, I'll email you both, and I'll make sure that you've got like an easy way to engage with that, and then just take your time with it. I'm sure there'll be some great questions in there, and I'm sure there'll be some stuff that you're happy to get stuck into, and that way, if you haven't had your question answered here, you've got two very good ways of following up. You can either email directly because you want to have a real conversation about that thing, or you just want a little knowledge gap filled, in which case, don't worry, we'll just get a little chat going for you.
Awesome.
Is that all right? Is that all right
Yes.
for you?
Sounds
Yeah.
it's great to me, and it was really lovely to sort of speak with you. You're lovely and sort of engaging and like interesting questions and interesting. Like we could have made this a 2-hour session easy. So thanks so much for giving up your lunch break to listen to us talk about law.
Yeah, no, lots and lots of jokes there about how we're going on tour. You know, we've got a 7-part series coming out.
Yeah, well, yeah, it'll be great.
But yeah, you know, everyone, if you found that really interesting, like, I think that really just speaks to the power of like how like absolutely captivating and compelling this stuff is, like, once you start having a conversation about it. And you know, Anna and Rahul have both proven that they can absolutely like talk the talk all day long. So if that's something you really want to follow up with, like, yeah, they're absolutely fantastic. They support Limit Break like almost every single year, and they just do great work. So get in touch. I'm going to bring our event to an end there. I have to end the recording for that to happen. So if you're watching this from the future, hello to you in the future. I hope you have floating cars now, and thanks for watching. I hope this has been a fun thing for you to watch.